Series hosted by the Georgetown Law Federalist Society. This series is dedicated to Daniel Webster, one of our nation's most revered orators and public servants. Webster relied on the strength of his ideas to advance the American people's liberty and prosperity. He is rightly remembered as the great expounder and defender of the Constitution. We are deeply grateful to the Federalist Society and to Georgetown Law for making this Daniel Webster debate series a reality. Tonight, our resolution is, should the court shut down its shadow docket? To discuss this important question, we welcome two outstanding professors, as well as our esteemed moderator, the Honorable Jennifer Elrod of the United States Court of Appeals for the Fifth Circuit. Judge Elrod was previously appointed and twice elected judge of the 190th District Court of Harris County, Texas, where she spent over 5 years presiding over more than 200 jury and non-jury trials. Before serving as a judge, Judge Elrod worked in private practice, focusing on civil litigation, antitrust, and employment matters. Judge Elrod graduated cum laude from Harvard Law School, where she was an active member of the Harvard Federalist Society, an Ames Moot Court finalist, and a senior editor of the Harvard Journal of Law and Public Policy. After law school, she clerked for the Honorable Sim Lake in the Southern District of Texas. Professor Stephen Vladeck is a professor of law at the Georgetown University Law Center. Professor Vladeck joined the Law Center's faculty in July 2024 after spending the first 19 years of his academic career at the University of Miami School of Law, American University Washington College of Law, and most recently the University of Texas School of Law. Professor Vladeck is the author of the New York Times best-selling book, The Shadow Docket, How the Supreme Court Uses Stealth Rulings to Amass Power and Undermine the Republic. He has argued over a dozen cases before the United States Supreme Court, the Texas Supreme Court, and various lower federal civilian and military courts. A graduate of Yale Law School, Professor Vladeck clerked for the Honorable Marcia S. Berzon on the U.S. Court of Appeals for the Ninth Circuit and the Honorable Rosemary Barquette on the U.S. Court of Appeals for the 11th Circuit. Last but not least, we have Professor Jennifer Mascott, who is an associate professor of law and director of the Separation of Powers Institute at Catholic Law. Her scholarship has been cited extensively by the Supreme Court and Federal Circuit and District Courts and has been published or is forthcoming in the Stanford Law Review, the Notre Dame Law Review, and the Supreme Court Review, among other prestigious journals. Professor Mascott previously served as Deputy Assistant Attorney General in the Office of Legal Counsel. She graduated summa cum laude from the George Washington University Law School, where she earned the highest cumulative graduating GPA on record at the law school. She is also a former law clerk to Supreme Court Justice Clarence Thomas and to then Judge Brett Kavanaugh, formerly of the U.S. Court of Appeals for the D.C. Circuit. Professor Mascott, actually, I'm repeated. I guess I was so impressed by the cumulative GPA thing that I wrote it down. And without further ado, I welcome Judge Elrod to introduce this fascinating subject. So please let us give Judge Elrod and our debate participants a very warm welcome.
Thank you, Ian. It was definitely worth repeating. That's great information. It's a delight to be here. I did not clap whenever they said that we were glad to have Professor Vladeck here at Georgetown, and that's only because we miss him so much in Texas. Although, you know, he is a Mets fan, so I question him. With that, I would like to use my first couple of moments to pay tribute to the namesake of this series, the lawyer-statesman Daniel Webster. As some of you know, Mr. Webster played a foundational role in the formation of our American legal system. He served in the U.S. House of Representatives, the U.S. Senate, and in the cabinets of Presidents Harrison, Tyler, and Fillmore. But he also was one of the most prominent lawyers of his generation, arguing over 200 cases before the Supreme Court, including at least one argument in almost every year between 1814 and 1852, a span of 38 years. That is even more arguments than Paul Clement. You may have heard of some of the cases he argued in support of the Bank of the United States in McCullough versus Maryland, and he advocated for Congress's commerce powers in Gibbons v. Ogden. Webster was known as one of the lions of the Senate who debated the important constitutional questions of the day, which we still reference to understand how our Constitution should be interpreted today. So it's a wonderful thing that your chapter has honored him with this debate series, and it's wonderful that you're having a debate just one day after our Constitution Day, and I appreciate you having me join you. I thought now, before we get into the debate, that we would play a little game, and you need to participate, or else it's not going to work, and you don't want me to fall flat. I have a former intern here, so I'm sure she'll participate if no one else does. So here we go. Here is your quiz. It's a trivia question. So here we go. Which of our participants hosts a podcast about parenting and lawyering in that order? And the answer is either Daniel Webster, Professor Vladeck, or Professor Mascott. If you know who hosts a podcast about parenting and lawyering in that order, please raise your hand and answer. You can guess. Yes.
Professor Vladeck.
Good answer. Bravo. Bravo. This one is a fill in the blank. During oral argument in the 2022 case, George versus McDonough, Justice Gorsuch asked the government's attorney the following question. And what do we do with Professor Blank's brief? Does anybody know who that professor is? 2022 case, George v. McDonough. Come on, someone guess.
It was Gorsuch asking.
Yes, Professor Gorsuch asked, oh, you're trying to give a hint.
Yes.
Okay, I see. Does anyone have a guess?
No.
It's Professor Mascott, but good try. It wasn't Daniel Webster either.
Gorsuch knows what to do with my briefs.
Enough said. Someone said the contest for the ages has been to rescue liberty from the grasp of executive power. Who once said that? Remember, the answers are either Professor Vladeck or Daniel Webster. Yes.
Is it Daniel Webster?
Yes. Testified before a 2021 Senate Judiciary Committee hearing titled Not at All Presumptuously, Texas's Unconstitutional Abortion Ban and the Role of the Shadow Docket. Testify that.
Professor Vladeck?
The trick question.
You're only half right. There's a second answer to this question, and who would it be? Mascott and Vladeck testified in that hearing, so you need to look at the pictures. The most notable thing is, well, let's stand up and show them.
I did
Stand for dramatic effect.
So 2 on 1.
Okay. Now that you've gotten to know the professors a little bit, or some of you may have the professor as your professor, so let's turn to the evening's main event, debating different perspectives on the so-called shadow docket. Now, I don't mean any disrespect to Professor Vladeck and his best-selling book's title, which I own a copy of, a signed copy, in fact, because I was one of the first 200 people to buy it, but I'm not advocating that you buy or read it, because that would be not appropriate for me to say. I just think people should read them. I like to use the docket's proper name, which is, what's the proper name of the docket? It's an easy one. It's the emergency docket. And it is also used to be referred to as simply the orders list that things would come out on from the emergency docket. Perhaps Professor Vladeck will tell you why I'm wrong and why we should use that other name. But I'm partial to something that Texas's Senator Ted Cruz had to say about it. He said it makes it sound ominous. He said shadows are really bad, like really, really bad. And I agree, shadows are scary. But I'm not sure that everything that happens on the emergency docket is so scary. Courts, not just the Supreme Court, have long managed emergency dockets. For a long time, most of the items on the emergency docket related to staying executions and death penalty cases in order to resolve any remaining legal issues. But courts, even lower courts like my court, use them all the time for considerations of all kinds of remedies, that they traditionally deploy, such as stays, injunctions, and expedited motions across a range of civil and criminal cases. The court's emergency docket was first dubbed the shadow docket in a 2015 article by University of Chicago professor Will Bode, and since then in Professor Vladeck's book, and in a vast amount of news coverage, discussions of the court's so-called shadow docket have taken on great prominence. In part, that is because the cases about COVID-19 lockdowns, immigration, and abortion have at times been disposed of on the court's emergency docket. But behind that controversy is a simple trade-off that admittedly can be complex in practice. Sometimes we need quick decisions and a quick resolution of issues. Sometimes we need the court to step in and prevent some sort of irreparable harm. But other times we need time, we need percolation, we need full briefing and argument, and we need to steepen the issues. And I suppose the hard part, the part our esteemed professors are here to debate, is knowing when one is more important than the other. So with that being said, I hand you over to your excellent debaters for this excellent debate.
Thank you very much, Judge Elrod. It's a treat to get to see you. I'm not sure all of your colleagues on the Court of Appeals would agree that they miss me, but I'll take one. So I just want to say off the top that I'm grateful to the Federal Society for having this event, but I do want to take slight issue with the prompt, which is, should the Supreme Court shut down its shadow docket? The answer is no, and we're done. Thank you very much. But rather, I think the point that I'd like to make in my openings and try to defend against the very powerful attacks I know are coming is that the Supreme Court should significantly change how it's been using the shadow docket. And so that's what I am aiming to prove to you today. So Judge Elrod mentioned Will Bode defined the term. While we're speaking of Ted Cruz blamed Democrats for concocting the term. If you know Professor Bode, he's many things. He's not a Democrat. Right, but Professor Bode meant it as a descriptive shorthand, not a pejorative. Shadows are the natural consequences of light sources and stationary objects. Right, not only for rulings on emergency applications, but for everything that the Supreme Court does through unsigned and usually unexplained orders. That's why I don't like the term emergency docket, just because that's not all of it. So just to take one example, in the same-sex marriage cases, you guys probably think that the Supreme Court legalized same-sex marriage in Obergefell. In fact, Obergefell only legalized same-sex marriage in 13 states. By the time Obergefell was decided, the Supreme Court had legalized same-sex marriage in 18 states through denials of certiorari. Those are pretty important orders if you were a same-sex couple trying to get married in one of those states, right? So Will's point that I'm trying to pick up on is that the Supreme Court does lots of really important stuff through unsigned, unexplained orders. You might like the bottom lines of those rulings. You might dislike the bottom lines of those rulings. What no one can deny is that they are very important. And what I set out to prove is that since the mid-2010s, the court has used unsigned, unexplained orders to a much more significant quantitative and qualitative extent than we've ever seen before. So I mentioned the cert part of this. Most of the shift, it's true, has been reflected in the emergency side of the shadow docket, where we've seen an unprecedented number of grants of emergency relief, where the Supreme Court is stepping in before a case gets to the justices through the normal appellate process, and some very high-profile denials, such as in the 2021 Texas 6-week abortion ban case. And with regard to emergency relief, there's nothing inherently pernicious about it. Right? We can all think of cases in which, because of the equities, because of what would happen if an appellate court does not intervene, there's a justification for some kind of temporary order that adjusts the status quo for the duration of litigation, right? Historically, the Supreme Court understood both that was true and that there were reasons to limit the circumstances and the effects of those kinds of orders. So until the 1980s, the Supreme Court handled just about every application for emergency relief by having the circuit justice do it, right? The one justice who's assigned to a particular part of the country. And this had two major virtues. Number one, circuit justices had much more flexibility. They often did hear in-chambers arguments, many of which were nowhere near their chambers. Justice Douglas once nailed an order to a tree. right, in Washington State. They could write in chambers opinions explaining why they had granted or denied relief, and no one confused a one justice order, even with an opinion, for a ruling of the full court. And that was how the Supreme Court handled emergencies, really throughout the 20th century until 1979, 1980. The court only moved away from that behavior starting in the early 1980s in death penalty cases, where because of the reinstitution of the death penalty in 1976, because of the divisiveness of death penalty cases, the court started having the full court resolve at least those kinds of emergency applications. And keeping with the norms that had arisen for certiorari, those orders would not come with oral argument. Those orders would not come with opinions. Those orders would not come with explanations. The shift happened really right about 1980, but no one noticed it outside of the death penalty context. If you ask people who clerked on the Supreme Court in the 1980s, 1990s, 2000s, what was the shadow docket? They would say death cases, and only death cases, right? It's only in the mid-2010s that we see a real shift in not just how often the full court is ruling on emergency applications, but in what those applications were about. Right, the real shift was not about the death cases. After all, the Supreme Court allowing one state to execute one prisoner might be a big deal factually, tends not to have massive statewide or nationwide consequences, right? But starting in 2016, we see this massive shift toward unsigned, unexplained orders that are either blocking or putting into effect policies affecting all of us. So, for example, blocking President Obama's Clean Power Plan, putting President Trump's immigration policies back into effect, blocking an array of state and federal COVID mitigation measures, allowing Alabama and Louisiana to use U.S. House district maps that violated the Voting Rights Act, right? All of these rulings came without majority opinions, right? You might like some of them, you might not like some of them. The key is they were all really significant rulings where the justices were not explaining themselves. And so to me, there are 4 problems with this behavior, and I want to sort of outline what they are and then get out of the way, right? Problem number 1 is the absence of guidance, right? So just to give you one example, this is from January, and this is the only time I'm going to mention the Fifth Circuit, like at least until rebuttal. Right, this is a case from the Fifth Circuit about whether President Biden could remove razor wire that Governor Abbott had put along the U.S.-Mexico border, and by a 5-4 vote, the court vacates an injunction the Fifth Circuit had entered. Guys, this is it, right? This is what the majority wrote. This is what the dissenters wrote. Spoiler alert, nothing, right? So how are judges supposed to know why the court ruled the way it did? How is Governor Abbott supposed to know what he can do going forward? How is President Biden supposed to know? We might be on different sides of the policy fight here, right? But like no one actually knows what the law is. That seems like a pretty big deal. Problem number 2, the court in this context is regularly flouting the standards of review that they're supposed to be following, right? One of the differences between emergency relief and the merits. Emergency relief is supposed to be justified by the emergency. We balance the equities. Well, there's a case from 2022, Louisiana versus American Rivers, in which 5 justices voted to stay a district court injunction that Louisiana waited 5 months to challenge, and for which it couldn't show any harmful effects during those months. They granted the stay anyway. So Justice Kagan, joined by noted liberal squish John Roberts, right, wrote that this renders the court's emergency docket not for emergencies at all. The docket becomes only another place for merits determinations, except without full briefing and argument. In the OSHA vaccination case, after summarizing how one side says the OSHA rule is going to cause millions of dollars of economic loss, and the other side said hundreds of thousands of people will die, the court just said it's not our job to weigh such trade-offs. If you know anything about equity, that is the court's only job in the context of emergency relief, is to weigh those trade-offs. That's supposed to be the whole point of the operation. Or if you prefer in Tannen versus Newsom, a 5-4 majority grants an emergency injunction blocking a California COVID mitigation measure based upon a new understanding of the free exercise clause. You might like that new understanding. I deliberately don't teach First Amendment, right? No one disputes it was new. In a context in which for years the Supreme Court has said you can only get this kind of relief for rights that are, quote, indisputably clear. How can a new right be indisputably clear? All right, So lots of examples of this. The third problem, the court is treating unsigned, unexplained orders as precedential. This is the Supreme Court's ruling in a case called South Bay 2 in February 2021. There's some words here, but I hope you will trust me if you can't read it, that there's no legal analysis here, right? This is the Supreme Court 3 weeks later yelling at the Ninth Circuit on the ground that the outcome in this unsigned, unexplained order was clearly dictated by this unsigned, unexplained order, right? These orders are not supposed to be precedential, and yet here we have the court overtly treating one as precedential. Finally, we have the problem that Justice Kagan has accused the justices of, which is applying these rules inconsistently. So, for example, we've seen the court act differently with regard to emergency applications in Trump immigration cases versus emergency applications in Biden immigration cases. We've had the court apply the Purcell principle in election cases in ways that have a remarkable tendency to favor Republican electoral outcomes and harm Democratic electoral outcomes. And because the court isn't writing opinions, there's no analysis that tries to reconcile these seemingly irreconcilable results. All right, so while all this is going on, and I'm wrapping up, this is also happening. If you don't recognize this chart, this is the court's merits docket. And the only thing I want to point out is over here, it is shrinking. Right, the court this term decided 59 cases. It's the 5th term in a row the court didn't get to 60. But 4 or 5 years ago, the last time that had happened was 1864. Why? Well, at least 3 of the justices have now said publicly that part of what's going on is they're spending so much more time with emergency applications. It's become a huge part of what they're doing too. That's new. All right, so I'm going to skip over the Kagan criticisms because I think I've rather paraphrased them already. Really quickly on Justice Alito, because I suspect he's going to come up. So Justice Alito gave a speech at Notre Dame Law School September 2021, where he criticized people who had been critical of the shadow docket, including me by name. That was awkward. And he says, right, the term shadow docket, this portrayal feeds unprecedented efforts to intimidate the court or damage it as an independent institution. And I just want to say, the problem to me is not the name or the existence of the shadow docket, right? The problem is the court's behavior on the shadow docket. And that would not be that hard to fix. The court should commit to providing at least a modicum of explanation when it is going to grant emergency relief. It should commit to identifying and then faithfully applying the correct standard of review. It should recommit to the principle that orders without reasoned opinions do not and should not have precedential effects. And insofar as this phenomenon is being caused by something else, the court should endeavor to tell us what. Why is this happening? It seems like this is something that justices should be invested in trying to figure out. So why should you care, right? This is not just a wonky debate about a technical part of the Supreme Court's docket. It's about the extent to which the Supreme Court's power depends upon its ability to explain its rulings. The point is not that we're always going to agree with the legal principles the court espouses. If you know me, you know I don't. Right? It's that we'll hopefully at least agree that the court's rulings are based on legal principles. That's why in an April 2022 speech at the Reagan Library, Justice Barrett went out of her way to urge all Americans, but especially the court's critics, to read the opinion before judging and criticizing the court. It's very good advice. And yet more and more, the court's handing down rulings with major impacts in which there's no opinion.
Professor, your time is expired.
And I'm done. Thank you very much.
Great. Well, thanks so much for having me here. I love being back at Georgetown. I did a fellowship here, and I'm really grateful to so many members of your faculty. Robin West, Greg Klass, Randy Barnett, Ben, Larry Solom, Josh Teitelbaum, lots of folks, the Dean, John McKyle. So take classes from all of them. They're fantastic, and really we're trying to help those of us younger scholars to develop our scholarship, whatever position it took, to figure out how to explain and deal with challenging ideas. And I really want to thank Professor Vladeck for being here because he's got young kids. spouse, evening time, and all of you. And it's so great that we're all taking our time tonight to think through these important issues. So in the past, well, actually, Steve Vladeck and I have talked about these issues many times in many different fora, which has been fantastic. We've talked about other issues, sometimes where we've agreed. So we actually filed briefs on the same side of important separation of powers case we hoped would go before the Supreme Court recently. So that's the other great thing I love about law, is that depending on the issue, it's about trying to get things right, what's fair, what's just, what's consistent with the law. And so alignments can change and they don't always necessarily follow what you would expect. All right, so on to the important topic of tonight. So in the past, when we've had these discussions, I have spent more time contesting or sort of responding to a lot of the statistics that Steve has really spent a lot of great time putting together about how the numbers on the shadow docket have changed over time, how the court's use of the emergency docket has shifted. And I also agree, emergency docket, orders docket is probably a more apt term. It's so funny that Steve talked about Will Bode entitling the shadow docket, and I concur that this all did come actually from a title of Will Bode's article. My recollection is that Professor Bode noted at one point that the title of the article was going to be a lot more prosaic, and so there was some discussion. Law professors like to banter about titles because we're trying to impress all of you with how pithy the topic is, so it to be published in the best journal possible. So I think it was in the pithy messaging construction that shadow docket was coined. I mean, obviously, there are lots of things happening in the government in the so-called shadows, right? I'm an administrative law professor, many scores of decisions happening constantly in the executive branch and agencies in the shadows and secretive. So I think tonight, actually, we can get more into the statistics perhaps in the debate or rebuttal or question and answer part. But I wanted this time to do something a little different and potentially contest at the threshold just whether there's actually something to be concerned about if things are in the shadows or not fully disclosed after all. What is the Supreme Court? Where does it sit within our system of government? What is the institution supposed to be doing? To whom does it have obligations, and what is its role? And as an initial matter, I think Professor Vladeck noted this too. I mean, certainly we can stand outside of institutions as observers and have concerns about how they operate. But I also want to just start that I think sometimes we have spent too much time questioning various institutions for their legitimacy or for their good faith approach in making decisions. And I personally think all 9 justices really are trying to do their best, often with many thorny issues, and that it is an institution, regardless of where we fall down the emergency docket, that merits significant respect, is trying to do a lot of hard work on behalf of the country, and really there's a lot to be grateful for with having folks who are such expert lawyers take the time that they do to serve on the nation's highest court with all of the attention that we put on it, and with all, quite frankly, the political pressure that's been placed, attention, how much debate and fervor gets stirred up when decisions are handed down that one side likes or doesn't like. So this is a general matter. I think it's always helpful for the temperature to be turned down when we're talking about institutions, and for us just to be thankful really in all the branches and all levels of government for who we have serving us. So is it a problem, even if the Supreme Court is issuing decisions that sometimes are not as fully explained as we like, that sometimes are happening more quickly than we want, that are coming up in the emergency docket? Well, I mean, I don't know. First of all, as lawyers, we all know that client confidentiality and deliberations are really important value. And we've got a norm in our system at the court within the judiciary already of confidentiality, being able to debate and deliberate over certain issues. Quite frankly, some of the bigger norms perhaps recently that have been broken are the breaks of those confidentialities, like in the press and leaks and folks talking about decisions that they don't like. Now, we can certainly learn a lot in the public and a lot for lower courts who are trying to follow precedent based on how much explanation the Supreme Court gives us. But even that has kind of changed over time. And so Professor Vladeck might know more of the specific date of this. But if you go back and you look historically, even at Supreme Court opinions, norms change over time. So it used to be that most of the opinion writing that you would see, for example, was a seriatim discussion by each justice of what they thought the decision should be. So the decision was actually the judgment, it was the answer, and there wasn't really as much of a culture of some majority reasoned opinion. You did get to hear what every justice thought, so in that sense there was transparency, but we really didn't have this idea that there was going to be a lengthy majority opinion that was going to have this agreed upon reasoning that was going to guide everything. And I think in part that stems from the fact that back in the day, the court, at least at certain points, had a more limited view or application of its role. And so it was a little bit more about deciding the dispute in front of it and binding the parties, in contrast to more of the modern culture where we see the Supreme Court opinions often telling us the answer. We want to know, is abortion a constitutional right or isn't it? Can a public servant have tenure protections or can't they? Did Congress have a part of this bill that needs to be severed? Does the agency need to be restructured? And so as society has turned to the court for bigger questions and it's tried to give bigger answers, we've turned to it more and wanted its reasoning more explained, but it didn't really always operate that way. And so it's hard, I think in that same vein, it's really hard to stand back and say that there's something that's inappropriate institutionally about what they may or may not be doing today on the emergency docket, because there are often shifts over time operationally in how institutions operate. Also, quite frankly, as far as confidentiality and transparency, there's really only one branch under the Constitution that has any disclosure responsibilities, and it's Congress. They have a responsibility at times to record votes of their proceedings, and but the executive branch doesn't, the courts don't, and indeed a lot of what we value about the court and its independence and its ability to not be influenced by political winds or public opinion. I don't think it's certainly not constitutionally required that various deliberations be kept confidential. It's not, required that they keep certain things private necessarily, but it's also not necessarily constitutionally required. I mean, we might think it's a good policy for them to give more disclosure, but there really is a value of this idea that I think if we allow there to be protected deliberations and have a norm of confidentiality and a norm of discussion and freedom there, it helps to facilitate this independence that we want the courts to maintain rather than being blown about by political winds. So where are we in terms of the emergency orders docket? I mean, Professor Vladeck is correct. It has often recently seen decisions of much greater consequence than it has in the past. So if we don't like the emergency docket, maybe we'd be concerned about that. Where is this pressure coming from? When Steve and I have talked about this recently, in the past, I really have said that I think some of this is being driven not necessarily by the justices trying to reach out and snatch issues, but a lot of this is them responding to how the issues come up before them. So we've had a rise certainly in national injunctions issued by lower district courts. We've also had more emergency actions taken by different branches of government, by the executive branch taking actions, and more litigants bringing challenges that have greater policy consequence. So, there are just a lot more emergency cases coming before the courts. And the court, often in ways that you might not expect, different from how you might think the court would rule in the substance, actually is on the orders docket declining to step in. So one recent example, this term the court will actually hear oral argument, for example, in this ghost guns case dealing with the Biden administration's decision to regulate gun assembly kits as guns under the Gun Control Act, and the justices essentially staying a decision below to make that regulation unoperational and defer to the political branches really by allowing that to remain in effect before it comes before the court. So, often the orders dockets being used to stop dramatic action, not necessarily to facilitate it. And a lot of the orders docket as well is the capital punishment docket. But it's become increasingly dealing with emergency action as government's taking greater action. So I think for me, the main point is for us just to think about institutionally what we want the court to be doing, how much disclosure we think is merited, whether the public needs to necessarily always know as much about the deliberations, and whether the court itself should be able to determine how it can best operate. The final point one of the statistics or slides that Professor Vladeck mentioned was about the justices not explaining reasoning and votes. And this obviously varies case by case, but when we're talking about the orders docket, actually, I think it was Professor Bode in a podcast pointed out one virtue perhaps at that more intermediate stage, especially in situations where the decision's going to go back down to the lower courts or come before the Supreme Court at a later time. Sometimes the justices not having to designate all of their names or their votes or their reasoning allows there to be less entrenchment of their decision at that particular intermediate point of time. So rather than trying to necessarily be secretive, they may be realizing and reflecting at this time, we're kind of having to respond in an emergency posture. We want to do our best, but we're going to give ourselves room to come back and revisit it later. So I think we all here respect the Supreme Court. I think it's doing a great job. And here for the emergency dockets. All right.
Professor Vladeck, you have 2 minutes for rebuttal.
I actually think I will not need all of it, but we'll see. So really quickly on the contemporary pressures point, I mean, I think we've had plenty of emergencies throughout American history, and I think in the old days the difference was that we expected lower courts to handle them, and that the need for the Supreme Court to provide emergency relief was mitigated by faith that lower courts were doing a pretty good job of calibrating when to intervene and when not. If that's gotten out of kilter, and maybe one argument that it is, the court should tell us that, and the court should tell the lower courts that, and that's part of how we got to this place in the first in the first instance. President Mascott mentioned the ghost guns case. That took 2 different grants of emergency relief from the Supreme Court to keep in place, right, the current regulatory regime. So that's unusual compared to where we were 10, 15 years ago. On the historical point, so it's interesting. President Mascott mentioned seriatim opinions. The Supreme Court abandoned that practice by the 1800s. Right, so 10 years into the Supreme Court's history. But the reason why that practice persisted in pre-revolutionary England was the view that judges had an obligation in every case to explain their reasons. It wasn't about sort of the need for sort of everyone's right just to write. It was actually like, you're a judge. Your job is to tell us why you're judging. So ironically, seriatim opinions seem to be consistent with the notion that the court should explain itself. And the last point I'll make, and I think this is really where perhaps there's some rich disagreement among us, I think the real question is, does the court have an obligation to explain itself? And this is both a historical question. I think it was easier when the court was hearing 75 cases a year, and that was its entire docket. It wasn't turning away 5,000 cases a year. This was the law until the 1880s, right? It was easier for the court to write in every case. Now the court gets 5,000 cert petitions a year. Like, everyone agrees there are some cases where the court can't write. But when the court is asserting power, when the court is adjusting the status quo, when the court is intervening, does it have an obligation to tell us why? And I'll just submit very, very briefly that that is exactly what the judicial power is. That the reason why we give the judicial power to unelected judges is in exchange for the notion that they're going to provide principles backing up their judgments. Not because we will agree with their principles, but because we will hopefully agree that they are principled.
Thank you.
So the seriatim point, I think, was more an illustration just about how process changes over time. And so I just don't think whether there's an increase, for example, in the emergency docket or not, is dispositive or particularly relevant to whether it's correct or not. Sometimes it reflects contemporary circumstance. I take the point also about the seriatim opinions giving explanation, but what they actually didn't do was collectively exercise the judicial power in an explained way. What they were doing was the collective decision and exercise of the judicial power in that instance was judgment. There was no collective one majority reasoning. So to the extent that today we would say we're using the majority opinion in a case to tell the lower courts how to operate. We just didn't have that in the same way back then. So I don't think the individual disclosure point is quite performing the work of the explanations and the majority opinions today. I think the larger point is the court today is reflecting the circumstances before it. And there's a lot of increasing emergency action taken by the executive branch. Congress in some ways has stepped back and kind of abdicated its role in a lot of instances by not updating statutes, by not giving legislative tools and instructions to policy decisions by the executive branch and agencies, or even to the court sometimes in stepping in and limiting the court's power in ways that we might find would be useful. And so the Supreme Court then is left to sit as the final arbiter of all of these tumultuous issues. And I think the use of the emergency docket and the pressure there's reflecting a lot of it. And I think the institution that's best equipped at this point to address it is Congress, by perhaps limiting or tailoring remedies, giving more instruction about how there should be operations, or even perhaps revisiting whether it makes sense to give the court as much almost complete discretion over whether it takes cases or not. But that's a decision that we should be turning to the political branches for, and not leaving it quite as much on the shoulders of the Supreme Court.
It's almost time for you to ask questions, so be thinking of your question. I have just 2 quick questions. And either of you can address these, but Justice Kavanaugh's recent concurrence in a case decided this past April, Labrador v. Poe, discusses several cases where the court had deployed mechanisms such as expedited oral argument to quell some of the emergency docket concerns. But he also pushed back against the argument that the court should issue written decisions on the emergency docket because of, as Professor Mascott was discussing, the potential to lock lower courts or even the Supreme Court into decisions prematurely. My question is, do you think Justice Kavanaugh identifies a good path forward for the emergency docket? Or if not, what is the ideal management of the emergency docket to look like? We're going to have an emergency docket. Professor Vladeck said so in his very first sentence. What should it look like?
Okay, there's a lot there. Really quickly, I think Justice Kavanaugh's Labrador concurrence, first, I think is a really valuable thing, because I think it's helpful for the justices to be publicly thinking and ruminating about this. It's helpful when they explain themselves. The thing I find troubling about the suggestion that there's a lock-in concern is sort of 2 pieces. First, that assumes that the court is asking the same question at the emergency phase that they're asking at the merits, right? The emergency phase is supposed to be, not just, are you likely to win, but do we need to rule for you now to protect the equities? It shouldn't be controversial that a judge could think it's like a 50-50 case on the merits, but that the equities are totally one-sided in favor of emergency relief. And then on the merits, might say, well, it's a 50-50 case, I've become persuaded. We saw that this term, right, with the EMTALA case. Second, right, Justice Kavanaugh himself provides the best recent counterexample. So in the Alabama redistricting case, where the Supreme Court intervened to let Alabama use a congressional district map that violated the Voting Rights Act, Justice Kavanaugh was the only justice in the majority who wrote a separate opinion to explain why. When the court on the merits struck down Alabama's map, guess who was the decisive vote? Justice Kavanaugh, who wrote a separate opinion to explain why, right? So it's odd for Justice Kavanaugh to say this is a real problem when he is the best evidence for how it isn't. As for the ideal shadow docket, emergency docket, potato docket, whatever you want to call it, so I actually think the pre-1980 system was pretty good. I think it did a really nice job of balancing the competing interests of wanting to have process, of wanting to have an explanation, of wanting to have the parties have a chance to be heard, and of not locking in the court to decisions that maybe hadn't been fully ventilated. If that's not possible, then I think we can at least and should at least aspire to the justices explaining themselves, at least when they are granting emergency relief in the subset of cases. This term so far, it's been 16 in which the justices are actually agreeing to intervene. Guys, in the last 4 years, right, the court has granted emergency relief somewhere north of 60 times. The Title IX case last month was the second in which there was a majority opinion. Right, so
thank you, Professor Vladeck. Professor Mascott, do you have anything to say on that?
Well, I mean, to the point about whether there should be an explanation every time relief is granted, I just think it's very dangerous. I mean, in our system, we have turned to the court as the Bible, like handwriting from God here in the United States of America, and we do not want the justices writing willy-nilly explanations just because they have to decide a dispute. And there has been a lot of emergency stepping in, but again, often it is the court coming in and permitting political decisions to move forward and stepping in a way that actually helps with the separation of powers, helps keep freedom with people and elected representatives. And I just am not as concerned as Professor Vladeck.
Okay, and the only other question that I have tonight has to do with, is the emergency docket, it's still going strong, I guess, because of there are many executive actions as, and agency actions, as Professor Mascott was discussing, and differences with states and things like that, and that I'm pretty familiar with. But will we see a lessening? Because we're not seeing as many nationwide injunctions. Is that gonna make all the difference, and so the numbers are gonna go down?
I mean, at least so far, the evidence suggests not necessarily, if not no. So, the court has before it right now 22 emergency applications. None of them relate to a nationwide injunction. Right, a bunch of them are actually challenges to 3 different sets of EPA rules. Right, none of which were emergencies. One of those rules goes into effect in 2032. Right, that's a very slow rolling emergency. Right, so I think the problem is that as the justices have, for better or for worse, and we might disagree about whether it's better or worse, as the justices have normalized this behavior on the emergency docket, more and more litigants are bringing more and more emergencies to the court that they might not have even brought 10, 15 years ago. And so, this right now it's environmental cases. In a month, it'll be election cases. Right, who knows where we'll be by the spring? There'll be a new president, one way or the other. They'll have some new policies that will probably be subject to immediate litigation and perhaps emergency litigation there. So I just think that the glass has been broken on emergency relief being unusual and extraordinary, and I'm not sure how you put the genie back in the bottle without some reforms from the court, or as Professor Mascott says, something from Congress.
Okay, did you have anything on this, Professor?
I mean, I just think the problem is not the court. The problem is the hyperventilation in society with all of this focus on the court as the final arbiter and all of this. I mean, look, every time procedural objections are raised, whatever institution it's with, whatever decision maker, it's usually because there's an objection to the substance and to the decision. And people have been talking more about the court, trying to undermine it institutionally. There's been more forward-leaning action. Part of it, started maybe perhaps a little bit with the pandemic or election relief. But the more that commentators, that scholars, that other institutions talk about the court, the more attention is going to be placed there, and the more problematic all of this is going to seem. And quite frankly, I am more worried about the safety and the integrity and the preservation of the institution and just federal institutions generally, when we're seeing not only personal attacks, but violent attacks now related to multiple branches of government recently. And I think that the temperature in general should be dialed down. And I don't think the issue is that the court is reaching out to take more of these issues. It's a larger issue of people undermining faith in institutions, putting all this attention on the court, and other branches of government trying to take bolder and bolder action and use the courts as a weapon rather than Congress stepping in. A lot of this should be addressed on the merits substantively by legislation with the statutes that are authorizing actions like that by the EPA that are being challenged, and then also by Congress really, I think, revisiting what kind of remedies should the courts be able to issue? Does it need to impact or frame jurisdiction differently? And make those policy decisions rather than leaving it up to the courts to face all of this pressure.
Thank you. Okay, do y'all have any questions? Yes, sir.
A question mostly for Professor Vladeck, but I guess really for anybody. If we went back to the pre-1980 system of circuit justices on their own handling these emergency matters, might that lead to disparate treatment geographically depending who your circuit justice is? Like some justices I know think as a matter of course, the death penalty is always unconstitutional. Condemned prisoners in those circuits are always going to get their emergency stay, whereas maybe not in other circuits. Might it be better to have the whole court do things to avoid that?
So, I mean, I think it's a fair concern in the abstract. In the world before 1980, we didn't have 9 centrists on the court. Right, this was a Supreme Court with William Brennan and, William O. Douglas, and, Warren Burger. These were not like, we all sing the same song about the death penalty, and yet somehow they got along. And it's because the circuit justices understood that their job was not to rule as they wanted to. Their job was to serve as proxies for the full court. There's exactly one example in the, really 50-year history of this robust practice of two justices openly disagreeing with each other, and it was over the Cambodia bombing in August of 1973. I'll say if it happened once in 50 years, that's not bad. I have a little more faith in the justices, even the ones who I tend to disagree with a lot, to take seriously the notion that their job as a circuit justice in that context is not to do their, what they want to do is to do what they think the full court would.
Okay. Did you want to respond or you good? Okay. Let's see, you got a question? Is there one from this side of the room? No? Okay, you can go. Oh. Yes, you.
Hello, thank you for being here and putting this on and this lively debate. This is wonderful. I'm a 1L, so I might figure out next week that my interpretation of this is utterly wrong. But I've always understood the court to mean that, the court gets its legitimacy from the support of the public. So don't you think that they owe an explanation to us when they dramatically alter our lives?
I think that's for you.
Well, I guess I also resist the notion that they're dramatically altering our lives. I mean, in a lot of these decisions that are being issued on the emergency docket, they're actually fending off what would be a dramatic change in life, or they're making a decision that takes their role away. And some members of the court think that the court gets its legitimacy from the public's view, but no, it's the one branch of government that is not elected. Now, there is a political role for the court, and it's in the nomination process by the president with the consent of the Senate. And after that, politics is done. Salary protection, tenure protection, we do not want politics and public influence over the justices. Now, that doesn't mean that it's going to be harmful for them to give an explanation to the public, but no, they really are sitting as the last arbiter of our rights and justice and need to have freedom in resolving cases and controversies. And if in a given case that works by giving the explanation, great. If it helps lower courts understand how to carry out the decision, excellent, but there is no constitutional value, period, that suggests there must be transparency in Supreme Court deliberation or issuance of decisions.
So let me say on the politics point, I think Professor Mascott radically understates the extent to which Congress is involved in virtually every feature of what the Supreme Court does. Without Congress, the Supreme Court would have the justices' salaries, no building, no paper, no computers, no law clerks, and no means of enforcing whatever they write on the toilet paper that they have in their bathrooms.
But not on the outcome of decisions and individuals.
That's fine, but you said you impeached that you said you confirmed the justices and you're done. And my reaction is no, actually, there's quite a bit more that Congress does to exert leverage over the court. Until 1891, every single case the Supreme Court heard was a case Congress told it to hear. Congress actually used to control every single feature of the court's docket.
You're not saying that's a positive thing, are you, Professor?
So my view, right? I mean, this is I think a slightly different conversation. My view is that our separation of powers, as Madison suggested in Federalist 51, is about ambition being made to counteract ambition. That Congress should be ambitious and the court should push back on Congress's ambitions, as it did, for example, in 1872, when Congress tried to tell the court how to rule in a particular pending case.
Ambitious branch. We were the least ambitious branch. That's a discussion about the other branch.
So I mean, in the very same passage in which Hamilton refers to the judiciary as the least dangerous branch, he's also talking about why the courts have the power of judicial review. And what made the court the least dangerous branch, according to Hamilton, was the fact that it depended upon us. That it depended upon popular support and the political branches for its judgments to be carried into effect. And just really quickly on the point about these orders not having real world effects, I think there are pregnant women in Idaho who would disagree, right? I mean, in the EMTALA case, just one of the most recent examples, the Supreme Court's intervention in January to put back into effect all of Idaho's abortion ban, which does not have an exception for cases in which abortions are medically necessary to treat an emergency, right? Unless it's one that is life-threatening. There are women who then had to leave Idaho to get proper abortion care, to get proper miscarriage care. So maybe those effects are justified, but I don't think it's fair to say there are no effects.
No, that's not what I'm saying. The Supreme Court did not come up with that policy and put that policy into effect. That was a political decision in Idaho. And
Which a district judge said was unconstitutional, and it was the Supreme Court that put the unconstitutional law back
But
into
again, so
effect.
see, I think you're illustrating the point, which is that really this debate here is not about the shadow docket. It is about which institution of government is supposed to do which things. And if one wants to rely on the Supreme Court to change institutions and political decisions, one may have the concerns that Professor Vladeck has, and one may want all of those political decisions to be explained. If one believes the court is the final backstop and almost all decisions, policies should be made by elected representatives at the state level and the federal level, one is not as concerned with the explanation of the court because it's supposed to be modestly deciding who wins and gets relief in a particular case, not refashioning society or standing back while another to interfere with a political decision that another branch has already made. On the politicization point, of course, Congress is intimately involved in the court's jurisdiction, as I think we've been saying most of the night, which is why I would turn to Congress to address some of these issues if we have concerns. I'm talking about politicization of arbitrating and resolving individual cases and individual decisions. And while the process of nominating justices is clearly completely political, there's no limit on it at all. If a president, for example, wants to, have certain arbitrary things they turn to in picking a justice, they have that power to do it. Once they are confirmed, lifetime tenure and salary protection is designed to make sure that the decisions in a particular case where they do have jurisdiction and they do have power to give relief is done in a way that is according to the justice's conscience under the law, not reflecting political winds and circumstances.
And how are we going to know that? And how are we going to know that those decisions are done in a way that reflect the justice's conscience according to law?
I mean, who do you need to know? Maybe Congress needs to know because it might want to defund them. Maybe we need to know if we think there's impeachment. Why do I need to know? And who's going to tell me what am I going to do differently? Nothing. I don't vote for them.
I think it's a pretty remarkable statement to say that we don't need to know why the Supreme Court is.
I feel very comfortable making the statement. I really do. Okay. Well, while over there, you should be very proud you asked an interesting question. So, okay, on this side of the room, let's see. Yes, sir, in the back.
Hey, Professor Mascott, I was hearing this argument that the court seems to be saying that you're saying that the court ought to look at themselves as a modest group who's like the final arbiter, and that we, the public, are ascribing too much on them and we keep looking to them. But it seems that Professor Vladeck is making the argument that the Supreme Court is welcoming that when they say that these arguments should be precedent, and then they're saying that we're doing the wrong thing by not looking back at those arguments. So,
well, I think in each case it depends on which way the ratchet goes. As sort of illustrating some of the discussion, sometimes the decisions are the court leaving in place what a political branch has done. And so in that sense, it's modest because it's either itself declining to step in or it is reversing a lower court's decision to step in. I certainly agree with your point that there are certainly justices and times the court acts in a way that is really not modest and is greatly stepping in with its explanations to try to refashion institutional systems. And I think that's been part of the problem, and it would be better if the court did that less frequently. I just don't think that problem and that concern is necessarily reflected in how the emergency docket comes down one way or the other. Yes.
would you agree that we as lawyers could discuss that more if we understood why they were doing what they were doing?
Discuss what more?
Discuss if they're overstepping their reach.
Well, I mean, to my earlier point, I think the institution that is best equipped to address that, and probably the only institution, is Congress. We don't vote for them intentionally. We can't kick them out. So I'm not saying it's bad necessarily for them to give explanation. I'm saying I think that the whole focus on the shadow docket debates suggests somehow that there's something surreptitious or nefarious or problematic with the court not giving explanation. I'm simply saying there's no constitutional reason institutionally that it has to do so. You green, or you, whatever color that is, chartreuse.
So never mind.
I'm sorry, yellow, okay, yellow, okay, never mind.
Yeah, so my question is along kind of a similar line. The Supreme Court is already a group of the 9 most powerful and least accountable people in the country, if not the world, set up that way for good reason, you know, in my opinion. But in what way does it actually benefit, to your point of turning down maybe the rhetoric around the court, the amount of scrutiny that we give them? In what way does it turn down the rhetoric to allow them and even encourage them to hand out these decisions, which however many, you know, building blocks you or dominoes you put between the policymakers and the court affirming these policies and saying that they're constitutional or unconstitutional? In what way does it benefit turning down this rhetoric to allow them to hand out these decisions and encourage it without any kind of explanation? Because they're not, as you equate them to like biblical, you know, texts handed down or equating their opinions to the Bible. They're not some all-knowing arbiter of good and evil like biblical God might be. They are people who are just interpreting the Constitution based on their opinions of how the Constitution should be interpreted.
Well, do you think that they're exercising more power by giving the decision? Or by giving the decision and then giving us many pages of mandates that we have to follow?
I think they exercise the same amount of power in both aspects. It's just in one, we are allowed to criticize and critique and at least understand why they're making that decision that a justice 20 years ago wouldn't have made.
But having been on the other side and talking to litigators, seeing how these things play out, everybody is reading the tea leaves of the explanation, and that's just not the reality of how it operates. When they speak and they give explanation and instructions, that itself becomes a larger, bigger morass at times of things for lower courts and states to follow. But if you have a particular, you know, decision that you want to talk about, we're happy to.
I mean, I disagree that that's a unique feature of written opinions. I mean, when the court in cases like the example I put on the slide says, hey, Ninth Circuit, you erred by not following this order that had no analysis. You know, what is a good Ninth Circuit judge to do? More to the point, what is the governor of California supposed to do? And the reality is that as the court, especially in the COVID context, kept issuing these unsigned orders, you had governors change their policies without being sure of whether they were lawful or not. You had lawsuits that were dropped because governors didn't want to continue defending them because they were worse. So it's the court's producing that effect one way or the other. I'd rather know why so that it's not actually being misread. I'd rather actually understand what the justices are doing. And just to your point about turning down the rhetoric, I'll just say, I tried very hard to assume that the justices are acting in good faith. One of the best ways they can prove it is by telling us what they're doing. I mean, I'm sorry. So when you have 2 sets of cases where the court is granting emergency relief in one and denying in the other, and the most sort of relevant distinction between them is the partisan valence, it seems like the insulation the court has against the charges that it's being political is its ability to write an opinion that says, here's why these 2 cases came out.
What's the biggest disclosure of recent time? It was the unprecedented release in advance of an entire opinion by Justice Alito of Dobbs. And you want to know what it led to? Assassination attempts. There we go.
So the court should. Wait. I'm sorry. I don't think. Sorry. I'm sorry. I do not think it is fair. Wait. Can I say what's not fair before you say? Okay. I do not think it is fair to equate a unprecedented leak of a draft opinion, which, by the way, I agree was wrong, right? With what?
I'm glad you agree it was wrong.
With what people like me are actually saying. When you conflate those 2 things, you are not turning down the rhetoric, right? What I'm arguing for is not more leaks. I'm arguing for in the formal decisions of the Supreme Court, which, by the way, are public, right? And are supposed to be public. I'm arguing for more explanation.
You said that giving explanation and telling the public why is going to legitimize the court and lead to people being content by the explanation.
That's not what I said. That's not what I said. What I said.
I'm just saying that what is being objected to is the substance of these decisions, and whether they're explained or not explained, there's going to be the same amount of questioning and the same amount of trying to change the institution. And and object to it, and you can see exactly what happened in the diocese.
So which is the last thing I'll say, because I know we're at time, with respect, I can't speak for everyone. Are there people out there who would hate, Dobbs, whether or not it had a written opinion or not? Sure. Is that everybody? No. Why? Because there are people like me who think that the Supreme Court has the right to say things I disagree with. Right? I think Dobbs is wrong, but I think that it's helpful that Justice Alito wrote a 98-page opinion telling us why. I think SFFA is wrong, but I think it's really helpful.
Thank
That's
you
important.
so much.
So to finish the thought, right? I think it's worth finishing the thought, right? There's a difference between saying the court has to write because they will persuade me that I'm wrong, and saying the court has to write so they'll persuade us that they're in court.
Thank you so much. Aren't you glad you came tonight? We appreciate both Professor Vladeck and Professor Mascott for taking their time. You're very blessed to have people with such expertise want to come and spend their free time visiting with us. And I learned tonight too. Come visit me in Houston. And all our best to Daniel Webster. Thank you.